Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular set of videos, we're talking a lot about Section 322 of the Citizenship Act. Now, what is Section 322 referred as? Okay, because again, it has to be filed minus some narrow exceptions before the child turns 18. It is referred to as the Expedited Naturalization of Children. And when did it come into effect? Well, it came into effect on February 27th, 2001. So if the facts leading to being qualifying under this were prior to that time, then you would have to look at prior sections of Section 322, prior law, in order to determine how to apply and whether or not it qualifies. But, just as a summary, for expedited naturalization of children, at least one parent is a U.S. citizen by birth or naturalization at the time of filing the N-600K. Okay, remember this. So this is naturalized expedited naturalization for the children. If the citizen parent deceased during the preceding 5 years, then the citizen grandparent or legal citizen guardian may file the N-600K. So that 5 years is real important. Don't let that pass if time is running and you might be able to qualify. And then prior to filing, the citizen parent has been physically present in the U.S. for at least 5 years, at least 2 after the age of 14, and a citizen parent has a citizen parent, which is ultimately the grandparent, who has been physically present in the U.S. for 5 years, at least 2 after the age of 14. Now remember, in that case, it's not the grandparent who's filing, it's still the citizen parent who's filing. They're just showing the physical presence through the grandparents. Okay, the child is currently residing outside the U.S. in legal and physical custody of the citizen parent, or if the citizen parent is deceased, an individual who does not object to that application. So of course you're going to need to get some evidence on how that person is not objecting, but usually a declaration would do. And the child is temporarily present in the U.S. pursuant to a lawful admission and maintaining lawful status. So this applies to adopted children under 18 if the child has met the requirements applicable to adopted children. Okay, so most importantly is that they would have to be adopted prior to age 16. And again, the 5-year limit, if the citizen parent has died, then the grandparent can file this particular application if within 5 years of the parent's death. Okay, more on the coming videos.